Hello and welcome everyone. I am Santosh Baliga, and in this particular video I am going to discuss about the topic of the concept of associate company as per the Companies Act 2013. This associate company has been defined under section 2 clause 6 of the Companies Act. Okay. Section 2 clause 6 provides that a company in which that other company has a significant influence, okay, but which is not a subsidiary company, of the company having such influence and includes a joint venture company. Okay, this is a definition which has been provided under section 2 clause 6. Now let us understand what this definition really means. See, we will understand this through an example, that is, say company A and there is a company B. Okay, company A holds a significant influence in the company B. Then company A would classify company B as its associate company. Now, this type of company is basically coming into from a categorization on the basis of control. Since company A has significant influence, so it has some amount of control over company B, and hence it can categorize it as an associate company. Now further, to understand this concept, we will have to first understand the concept of significant influence. Now significant influence means there are two ways in which a company can have significant influence over the other company. One, if the company is holding how much? At least 20% of total voting rights in the other company. So company A, if it is holding at least 20% of the total voting rights in company B, then in that case company A will be said to have significant influence over company B, and company B will be the associate company of company A. Okay, now there is one more way in which you can have significant influence. Say the company is not having 20% of total voting rights, still it can have significant influence. That is by the company having a control or participation in the business decisions of the other company. This power is provided to it by a shareholders agreement. Okay, this part is clear. So the second point, I will repeat it once again, that a company A has a right to participate in the business decisions. So it can have a say in the board meetings, it can have a say in the meetings of the company, it can have a say in the resolutions of the company, and that say is significant, then it will be called as a significant influence that company A has over company B. Now you would say, how would it have the right to participate in the business decisions of company B? That would be possible if company A and company B have got into an shareholders agreement, or an agreement through which the right to participate in the business decisions has been provided to company A, and then in that case company A will be called to have an significant influence over company B, and company B will be the associate company of company A. So this concept is clear through this example. So we will get into the text of the provisions that has been provided. So expression significant influence means control of at least 20% of the total voting rights. So at least 20%. So it is at least 20% of the total voting rights or power that a company should have over the other company to have a significant influence. Second is, this is an or, that means any one condition if it is met, then we would say that it is a significant influence. The second point is control of or participation in business decisions under an agreement. So a company which has a control or participation in business decisions of the other company, in that case the company would be said to have a significant influence over that other company. So I hope the point of significant influence is absolutely clear over here. Now the one more important point that is left in the definition is it is not a subsidiary company. What does this mean? We have learned what is a subsidiary company. Subsidiary company is a company in which the holding company is holding more than 50%, more than how much? 50%, or you can say one half of the total voting rights. Okay, so if a company has more than 50%, your question will be this is more than 20% also. That means what is the difference between an associate company and a subsidiary company? But the point is, if a company has more than 50%, then such company would be called as an holding company of such subsidiary company. But if a company has 20% to 50%, 20% to 50%, then in that case it will be called as an associate company. So it has an influence over the company but does not have full control over the company. Okay, if it has more than 50%, then it has full control because it can pass a lot of ordinary decisions. A lot of board meetings can be board meeting decisions can be taken by such a group which has such kind of an stake in the company. Okay, so going back, we have understood the definition, we have understood the expression of significant influence also. Now, if a company has an associate company, in that case, some of the compliances which have to be done are basically that if the company which has an associate company, like say company A has an associate company, company B, so in this case, any contract or any transaction that is done by company A with company B will be considered for it as a related party as per section 188 of the Companies Act. Okay, so section 188 is a very exhaustive section in which it has been provided that company needs to make some disclosures before getting into the transactions with such related parties. Okay, so that's the first point that I want to cover over here, related party transaction. Second is any company which has, say a company has company B as its subsidiary company, company C as its subsidiary company, and it has company D as its associate company. So in that case, company A's financial statement has to be a consolidated financial statement. Which financial statement? Consolidated financial statement. And in that case, this consolidated financial statement will include the financials of the company B, company C, which are the subsidiaries, and also company D, which is the associate company of company A. Okay, so this is also one more compliance that has to include the financial statements of associate company in its CFS. CFS means consolidated financial statement, and this is given under section 128 of the Companies Act. I hope you have understood this much amount of concept in associate company, which is necessary for you to know for the examination point of view and from knowledge point of view also. What is the difference between an associate company and subsidiary company? You should be able to answer this by now, that associate company will have a minimum of 20% to 50% of the total voting power, whereas a parent company will have more than 50% of the voting power. And one more thing over here, I had said that it is up to 50%, so it should be less than 50%. It should be less than 50%. So an associate company will have 20% to less than 50%. So it is 20%, but less than how much? 50%. But in case of subsidiary company, it is more than 50%. So you have understood this one particular point. The next thing is that parent company has a significant influence, that is a power to participate, but not a full control. Okay, so in case of subsidiary company, it is a controlling power. Controlling power means it has full control over the other company, that is a subsidiary company. Okay, so there may be presence of certain number of common promoters and directors, but in case of a subsidiary company, the holding company has the full control over the management of the subsidiary company. Okay, so these are the distinction between associate company and the subsidiary company. Okay, so with that I would close this particular video, and I hope that this particular video has been useful for all of you. You have understood the concept of associate company. If there is any doubts, do write to me in the comment section, and I would respond to you very happily. That's it from me in this video. Bye bye.